rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Let me ask our bailiff if we have the sign-in sheet. Thank you very much. This is the time set for oral argument in our case number CV19-0221, Rizzio versus Surpass. Each side is allocated 20 minutes for presentation. Appellant may reserve a portion of that time if you wish to do so. If you wish to do so, you'll need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask that those in attendance make sure their cell phones are off so that we can avoid any interruption and any embarrassment. We have read the briefs. We've conferenced the case. We're familiar with the record. We encourage you to keep that in mind as you present oral argument. Our proceedings are being posted on the internet, including to YouTube. As you begin your argument, accordingly, we would ask that you please start by saying your name and the party that you represent. With that, Mr. Smith, you may begin.
Good morning, Your Honor. May it please the Court. My name is Bruce Smith, and I represent the appellants. For purposes of the oral argument, I'm going to refer to the appellants collectively as Mariposa Point. I would like to reserve 5 minutes of my argument time for rebuttal. 95 years ago, give or take, Congress adopted the Federal Arbitration Act, and it did so to do away with, or attempt to do away with, antagonism to the arbitration process. Arizona adopted its own arbitration statute in 1962, and it had adopted another arbitration statute in 2010. Unfortunately, courts and state legislatures throughout the country have remained antagonistic to the arbitration process, and as a result, our Supreme Court, the United States Supreme Court, has advised that courts must be aware and mindful of overt and covert means of avoiding arbitration. And with regard to the covert means, they are looking to arguments that may be neutral on their face, but in application are actually discriminatory against arbitration. In this case, that is what we have. We have both overt and covert discrimination against the arbitration process by the trial court. My arguments this morning are going to focus on 4 key points. First, this is a case governed by the Federal Arbitration Act itself. Second, the court committed error by concluding that the arbitration costs were substantively unconscionable. As an aside or a secondary argument, the Arizona legislature has already taken into consideration that there are arbitration costs. So the fact that one would conclude that merely paying arbitration costs is substantively unconscionable is contrary.
Is that really what happened here? It's not just that the general proposition of paying costs, it's the specific provision at issue which explicitly binds the resident to cover all costs, including your client's costs, under all circumstances. That's what the court found. Is that correct?
Yes and no. The court also focused in on the fact that Ms. Rizzio had a fixed income, and Ms. Rizzio's fixed income, in the court's mind, barred her from being able to pay the arbitration costs. What the court mistakenly did, however, was leaped to the conclusion that in a case in which you have an attorney's fees agreement that requires all costs to be advanced, that Ms. Rizzio would have to, in fact, pay those costs.
Well, before you get there, let's go back to the question that was asked. Is it your position that the contract at issue here required the residents to pay all costs no matter what?
If you look at the arbitration provision itself, Judge McMurdy, it says 2 things. It does, in fact, reference that arbitration costs of the facility should be paid by by the resident or the resident's family. However, it also makes a provision in which it states that if we are required, it's on page 1 of the document, it also says if the arbitrator chooses to award the cost of the additional arbitration against us,
What's the additional, that's the confusing part to me. What does additional arbitration mean?
I would interpret that to mean, Your Honor, that if the arbitrator were to decide that the complaining party prevailed and was entitled to an award of arbitration fees, then that party would be entitled to collect those arbitration fees.
So it's your position that the particular contract at issue here does not require the resident to pay all costs no matter what?
Well, presumptively, it does. But it also carries the proviso that if you go into arbitration and the arbitrator were to decide...
If you go into additional arbitration. I mean, that's really the crux of the concern here, is that sentence suggests that there is some arbitration and then there is some additional arbitration. And in the case of that additional arbitration, then the fees and costs can be awarded as against the community. But how do we square that with what you're saying here?
Well, in this case, I believe that the additional arbitration costs against us and directed to pay as directed by the arbitrator necessarily encompasses what the Arizona legislature has envisioned in its statutes and what federal courts have said is permissible under the Federal Arbitration Act, in that a prevailing party is able to collect their arbitration costs.
Right. The concern that I have is that the Arizona legislature has explicitly said, unless otherwise provided in the agreement to arbitrate. So in section 12-1510, the fees and expenses of arbitration, we're in the land of what the agreement says, not what the legislature has said. Isn't that what that statute tells us?
Well, yes and no. It was not cited in my papers, but I was looking at the article that former Judge Meyerson wrote regarding the Revised Uniform Arbitration Act. And in the Meyerson article, the way he envisioned this statute is that subsection B deals with...
So that's a different statute, but yes.
Right. Subsection B deals with attorney's fees and other costs that the parties contemplate being awarded, and subparagraph D deals with arbitration costs themselves.
Counsel, let me ask you, let me see if I can replay this. Your position is either under the language of the arbitration agreement or notwithstanding the language of the arbitration agreement, that the arbitral award at the end of the day could allocate the cost of arbitration to the prevailing party regardless of who that party is.
Correct.
And I understand that, and thank you for...
Are you saying costs and fees or just costs?
No, the fees itself in subsection B, the attorney's fees provision was added because under the old arbitration statute, there was no reference to attorney's fees, and the Arizona courts had interpreted that to mean that if arbitration was going forward, the attorney's fee statute did not apply to the arbitration itself. And the legislature corrected that in 2010 under the Revised Uniform Arbitration Act so that 12-341 attorney's fees can now be awarded for the arbitration process.
All right, sorry.
No. To follow up, though, on my attempt at replaying this, the language used, though, in the arbitration agreement doesn't do a very good job of saying that, does it?
No, I would agree that the language itself is not that specific and is not that clear.
And in fact, the trial court, I think, read it as saying something quite different than what you're describing. It read it as saying, hey, the resident is responsible for arbitration costs if the resident wins or if the nurse if your client wins. And that's not an unreasonable read of this provision. So I guess I understand your position, which is really kind of a concession. But we're here, I think, given the thought that an arbitration agreement should be clear and understandable and, with the policy of enforcement that you've made reference to under 3 statutes, 1 federal and 2 in Arizona. But we're asked to put some knots into some, contractual language to get to your position. And I struggle with that.
Well, the other thing that the court has to keep in mind is that the arbitration provision itself has at the very end a clause that states if any provision is found unenforceable, the remainder of the document takes effect. And what the court did not do below is to say, I believe that this provision regarding fees and costs is unconscionable. However, the remainder of it stays in effect. And the one thing that the U.S. Supreme Court has said time and time again is arbitration agreements are to be enforced as written. And when you have a provision that says if something is found unenforceable, the remainder of that document stays in effect. And here we have a provision that talks about the parties both being bound by arbitration. There are references to rules that would be used, selection of an arbitrator, and it's clear that the arbitration process itself would go forward. That process...
Can I, just because your time's kind of ticking down, let's set aside on severability, okay, this provision, if we find it unconscionable, we sever it. Talk to me a little bit more about, I think it was Clerk v. Renaissance West and the overall costs. You're talking about the trial court's findings about fixed income. Talk to me about that line of law telling us that the individual's ability to afford the arbitration process may itself implicate substantive unconscionability on a more global.
If you look at the Clerk case, and one of the reasons why we provided the court with both the opening and responsive briefs is there is no mention in the Clerk case at all of a contingency fee agreement with the Clerk's firm. And the Harrington court said a contingency fee agreement in which costs are advanced is a way out to determine if a person does or does not have a financial means of vindicating their rights in arbitration. So the contingency fee was not ever at issue in the Clerk case. And here it is clearly at issue. The difference here is we have Ms. Giorgiani testifying, I expect all costs to be advanced by my attorneys. Their expert, Mr. Sammons, agreed under oath, I also believe that all costs are going to be advanced by the plaintiff's lawyer. And when you have a situation in which all costs are advanced, it doesn't matter whether it's deposition transcripts, filing fees, experts, or arbitration costs, Ms. Rizzio is not going to pay them. And there is no evidence in the record that despite the contingency fee agreement, that her lawyers are going to make her pay as she goes for any of these costs.
Okay, thank you. That's very helpful. I want to get you to a few of the things we wanted to talk about, and you have limited time. Taking us back to the language of the agreement, if we were to agree with the expert arbitrator and the court that the final sentence of the cost provision, that additional arbitration sentence, if that's incomprehensible or something to which Ms. Rizzio, through her power of attorney, could not have agreed, doesn't that take us into the land of procedural unconscionability? And could you talk very briefly about that? In other words, if there's something in the agreement that is not able to be understood.
Well, I don't think that this is a situation in which procedural unconscionability would even apply, because if you look at the record, and I believe it's appendix page 23, Ms. Giorgiani talked about what she did when she signed this second set of documents. She said she went in and she signed them as quickly as possible. She
So it
wasn't
doesn't matter if there's a provision that's incomprehensible if she didn't read it? Is that what you're saying?
Well, in the context of this case, I don't think there was anything procedurally unconscionable about anything that was presented to her. There were a set of documents. She quickly got them. She admits that she quickly signed them. She didn't read them. The Ross versus Drexel Burnham case says it doesn't matter whether or not you read them or
I
not.
guess what
You're
I'm
still
getting at
bound by
is,
them.
as a matter of law, if there is an incomprehensible provision in a contract, does that render the contract unconscionable as a matter of procedure? Because, so that's just one of the legal questions I have. So setting aside the other factual circumstances, as a matter of law, would that render us in the land of procedural unconscionability?
No, I don't think it would
Okay.
render the entire contract. It might render that particular clause unconscionable. But you have to remember that one of the problems that you've got in arbitration, one of the arguments that they made is no one explained this to you. No one explained arbitration. How does one explain arbitration? How does one explain the Federal Arbitration Act? Do you explain it's a big case or a small case? I mean, my research notebooks in the office are literally this big on arbitration cases. So the idea that you would have a procedural mechanism of explaining all of these things is simply not accurate. And as the Darner Motors case talked about with regard to reasonable expectations, the Supreme Court recognized that form contracts are presented by people who are not versed in the law, and these people may not even know that these provisions exist in these contracts. Nevertheless, those contracts still remain in effect because that is the way that modern commerce works. And we are, again, working on contract neutral principles here, not anything that's arbitration specific. So
Would you say this was a contract of adhesion? Which isn't necessarily render it one way or the other, would your characterization, would you agree with that characterization?
I would agree with the court that it is a contract of adhesion in that it is a form that is presented to somebody. I would disagree that by saying that it's a contract of adhesion, that there is any kind of a negative connotation. I see that my time is up, if there's no more further questions.
Very well. Thank you, Counsel. Mr. Wright.
Morning, Your Honors. My name is Lincoln Wright. I'm here for the plaintiff, Ms. Rizzio. May it please the court. This court has already decided this case in Clerk v. Renaissance West, both on the facts and the law. We have very similar facts and very similar law. The trial court here held an evidentiary hearing. She took extensive testimony. She made findings of fact based on that record and properly concluded under this court's analysis that there were prohibitively high arbitration costs which made this unconscionable. Besides the
But could you address your colleague here's point about the fact that you are advancing those costs? So as a matter of fact, in this case, it's a fairly significant distinguishable fact from Clerk. This individual is actually not responsible for those costs, certainly not up front.
There are several reasons, Your Honor. First, all of the case law from Greentree versus Randolph, the Supreme Court case on down, have focused on the plaintiff's ability to pay rather than their attorneys. We cite several cases in the circuits, Cole versus Burns. There's a Castillo case where...
But all of those cases, in focusing on the plaintiff's ability to pay, talk about whether that forum is thereby closed to them. That's not the case if counsel's fronting the fees and costs, right?
I understand what you're saying, Your Honor. In this case, because of the clause that we've been focusing on that says that the resident has to pay the defendant's costs and legal fees, attorney fees, on top of the arbitration cost, regardless if she wins or not, that renders...
But they just conceded that that's not how, that's not what it means, that the arbitrator can actually award to you cost and fees.
We disagree with that interpretation, Your
Well,
Honor.
they've conceded that point.
Well, that
That
it
you
is-
can acquire your costs and fees if they win. If they're did they concede that
I
point
don't-
in front of Judge Stevens?
I don't believe so. I thought that there was some debate about whether there was an additional arbitration. They had to go for another round of arbitration.
That's
or
the
what
last,
exactly
that's
it
the
meant.
last sentence in paragraph 1. I think what we were talking about was the next to last sentence in paragraph 1.
Costs
And
are to be borne.
and as well as attorney's fees and other things. And I did hear today, at least, appellant's counsel saying, no, the arbitrator would have the discretion to make a fee cost award in the award to the successful party or not, notwithstanding the language in the contract.
If that's the case, but a resident approaching this would not know that. And so.
And I understand that sort of in the abstract. Obviously,
Yeah.
we're not in the abstract today. And Judge Stevens was not in the abstract when she was asked to assess these things after considering evidence. So I definitely want to hear your thoughts on what matter, if at all, that would change.
Even if even if our client did not have to pay the entire amount or any portion, the fact that she had to bear something over and above what she would have to do in civil court means that at the end of the day, that reduces her award. And so that is fundamentally unfair.
Is
when
that true even, I mean, let's get into the abstract realm. Here the difference is quite significant, hundreds versus tens of thousands, at least from the record we're presented. But what if it was $600 to initiate a civil case and $1,000 to go to arbitration? Is your argument really the same? That if it's a penny more, it's too much?
No, Your Honor, and that we can absolutely conceive of an arbitration agreement that would say your arbitration costs would be this much, and if they are if they are affordable to the client, then absolutely. And that's why I go back to your reasoning in Clerk. If if the plaintiff has the ability to pay, then that might render the agreement valid. Or if there are provisions whereby the arbitration costs would be reduced or waived based on financial hardship, that would be another way that the arbitration agreement could remain valid. So we're not saying, as counsel just claimed, that any arbitration costs would be per se unconscionable. We see that there are benefits to going to arbitration and that you would have to pay arbitration fees. It's the amount in this particular circumstance where to bring adult protective services claim, you have to bring in expert testimony on several different things. The expert arbitrator testified about those costs, so they're substantially higher than an ordinary arbitration case would be.
Well, but that's true in litigation as well. I mean, doesn't your argument really turn on the difference between, let's call it $600 and $22,000?
Yes, in a lot of ways.
And at some point, there is some number in between those two that causes things to tip. We don't need to identify that, but it's something more than $601 and something less than $22,000.
We would absolutely concede if the costs were affordable enough and there were provisions, say either in the arbitration agreement or based on the plaintiff's ability to pay, that would render that valid and conscionable, then absolutely.
Well, you keep talking about the plaintiff's ability to pay, but shouldn't we consider that in the ability to pay, the fact that you represented to the court below that your firm would upfront those fees, so they had the ability to pay? Again,
that's not within the jurisprudence. We've discussed that, but
well, okay, let's talk about ability to pay. So if your client had a rich aunt who was going to upfront for the fees, wouldn't we consider that ability to pay? She has a rich relative.
Absolutely.
Well, then why wouldn't we consider the fact that the firm has said we'll upfront those costs?
Well, then you get into how much the cost is, and that's why the analysis in Clerk it works so well, is because there are several factors for the trial court to weigh. If the plaintiff has the ability to pay, or if there is.
But the second factor is an individualized, case-specific, fact-based inquiry into the ability to pay, which is exactly what Judge McMurdy is getting at. In this case, this individual, under these facts, had the ability to pay by virtue of her attorneys having agreed to pay. So,
Well, the trial court here found that even though she mentioned that there was a contingency fee agreement, but she still focused on the plaintiff's ability because of Clerk. And I think that was a distinguishing fact there. But
Is that a legal isn't that a legal thing that we can disagree with? I mean, we could say, no, you should have looked at everything, including the contingency fee, not just
Sure.
on her individually.
But that's just one element of what the trial court found. The trial court also focused heavily on the procedural unconscionability aspects. So even though there might be a contingency fee agreement here, there still were the unequal bargaining and the lack of opportunity to bargain between the parties that rendered this unconscionable as well.
Doesn't that, on the procedural unconscionability, which is really what you're talking about, doesn't that prove too much, though? I mean, doesn't your argument suggest that never in this context could you have a form arbitration agreement that was enforceable? And that seems contrary to my understanding of the cases under the FAA and Arizona's two arbitration acts.
I don't believe so, Your Honor. I think there are definitely, we've seen cases where a facility will concede several things or say, so X out certain portions of the arbitration agreement, or the resident refuses to sign it and they still are able to be
but I
admitted.
think Judge Thomas' point is still an important one, which is in the absence of a pushback, does that mean always, if you're in the land of the resident or power of attorney not trying to challenge the agreement, then it's invalid? It's per se invalid because they just signed the agreement.
I think then we go back to the reasonable expectations test of Darner and Maxwell, where yes, the resident would be bound by reasonable arbitration terms, but where it gets into the fact that there are several thousands of dollars that they would have to spend to bring this particular type of claim in an injury setting, then that is a bizarre and one-sided or unfair surprise that they would not ordinarily adhere to, and that was the testimony in this case.
Doesn't that, though, conflate substantive and procedural unconscionability? I mean, what you're describing, if that were the case, you would never, procedural unconscionability wouldn't kick in, would it? Because your argument would be, well, wait a minute, this is substantively unconscionable. Has nothing to do with the process of how the contract was entered. It has to do with the terms of the contract itself.
I see your point, Your Honor, and I think that's sort of where the case law is muddled because it typically does get into substantive unconscionability. But there are other factors that the court looked at, Ms. Giorgiani's relative inexperience, and then her concern over her mother, talking about how that might have put her under duress so that she was not in a proper frame of mind to negotiate and look at things.
But didn't, and we're focusing on one arbitration agreement, but there were two here, right? I mean, at different points of time, agreed to months apart.
Well, yes, and we had a lot of, at the lower court level, focus on whether she actually signed at one point, and she did. We conceded that she eventually signed. However, the discussion was so brief. In April, the testimony was that it was about 10 to 15 minutes.
But wasn't it brief because of Ms. Giorgiani? And she was the one pushing to get it signed, to get her mother taken care of, to move into this. So to the extent that she lacked sufficient time, if that's the argument, wasn't that kind of on her shoulders?
True, but I believe that the burden for the party moving for an arbitration to be found valid has to show that they then provided the opportunity for the other side to bargain. or to examine those terms and have those terms explained to them. I believe.
What's your best case that that arbitration agreements subject to the FAA require individualized explanation of the arbitration agreement itself in order to be valid?
I believe Darner Motor Sales, the reasonable expectations test. If there are things that are going to, and again, we get into the high arbitration cost, which admittedly is substantive, but
We're kind of conflating unconscionability and reasonable expectations, but aren't those separate concepts?
they are to the fact, but in the Bremer case, that it took that and sort of said that the reasonable expectations is per se procedurally unconscionable if that process has things which were not explained to the consumer, that is not aware of such things, then is not sophisticated.
Well, wouldn't that be everybody? I mean, who goes in for these things with an expertise in that area, short of lawyers?
Several of the cases, the Casaroto case in the Supreme Court, talked about the fact that the claimant was experienced businessman and had experience with contracts, and therefore that weighed against the procedural unconscionability. So it definitely is an individual case-by-case basis, which is what we're asking for the court to apply here.
But let's take that to its logic. What I would view as its logical conclusion, absent a lawyer or an experienced businessman, which is what percent of the category do you think that would be? Maybe 3% or 4% of the entire contracting world. So we got 97% of or some astronomical number of people that you have to explain arbitration agreements to these people in order for it to be valid?
In this particular case, and that's why arbitration agreements in elderly care setting have been so fraught, and there have been many, it's been controversial in the recent Health and Human Services had made a rule that they should be forbidden in all nursing home settings, and then that was reversed with the recent administration. So it is a subject where, because of the situation where residents who are vulnerable, who may have some cognitive deficits, are asked to sign their rights away, even when they're injured, to come into a nursing home or an assisted living facility.
Well, that's a different answer to the question I gave, because we're talking if the person who's signing the contract has a cognitive deficit is one thing. We're talking about just the regular person that goes in and is presented with one of these contracts. And you're saying, oh, they should be explained to arbitration. Well, what percentage of the cases does that mean? If we held that, what percentage of the cases would they have to have a detailed explanation?
Again, it's the unique aspect of this situation where, in an elderly care setting, to bring a claim when someone is injured, they have to bring in expert testimony in several areas, and then the arbitrator will charge for that time in listening to that evidence. So it differs fundamentally from say a phone company arbitration agreement, where it's the difference about a bill or an economic dispute, but there's no injury there. That's why the court in Harrington and in Clerk has talked about the aspect that this being an injury, and that it takes additional expert testimony to be able to prove a claim.
All of that
is
again
what
gets to
charges.
costs, which brings us back into the land of, but we have this contingency fee arrangement, which is distinguishable from those cases, right?
True, and our argument is that at the end of the day, that a plaintiff should not be penalized just because they have a contingency fee agreement. that they will have to pay those additional costs.
Is it
Well,
a penalty, or is it just holding her to the agreement that she signed? I mean, that's
Yeah, I
again,
see your
because sort of
point.
taking us into the land of the 90s or earlier of sort of anti-arbitration, which is not the current state of the law.
I see your point. But in this particular provision, because it has the clause that said you must pay all the defense costs regardless if you prevail or not, that additional burden, I think it makes this especially egregious.
Well, except they've now conceded that that's not what this says. So they've said exactly opposite, that you go to arbitration, if you win, you'll get all of those costs paid for by them.
I don't believe that that's what has been conceded, but
Here or below? Because
well,
I heard him say that.
I think what Mr. Smith said was that there could be circumstances where that would happen. However, that it could also be where that the resident would have to pay regardless. And that's on its face, that's what the language says. And so if that had to be upheld, then that would be unconscionable.
What sort of impact on this area of the discussion do the two bolded provisions in the agreement have? The first saying the community encourages and recommends that you obtain the advice of legal counsel to review the agreement, and that at the very end, admission to the community is not contingent upon signing this agreement. Ms. Giorgiani received this twice, so even if she didn't review it carefully at the time, at some point between the first signing and the subsequent signing of the contract at large, she had the opportunity at least to see that the community recommended that she seek legal advice about the arbitration agreement. Doesn't that bear some weight on our evaluation of this individual case?
I don't think so, Your Honor. I think that, again, these bolded provisions, they don't say anything about the cost that they would have to pay, nor the penalty that the winner would have to still pay the loser's costs.
Well, they don't quantify the cost, but the agreement itself does talk about the costs, and the signature block says the parties have read this arbitration agreement. They avow that.
Yes, again, and the testimony was that she had not read it, and had she been explained that she would have to pay thousands of dollars to bring a claim, she would never have signed it. So that gets back to Darner and that the fact that consumers are not held to terms that are bizarre, they would not agree to had they known about them. So that is one provision that should have been explained, and that's our position, is that when it becomes such a financial hardship, then that's something that had to be explained. Thank you, Your Honors.
Thank you. Mr. Smith, rebuttal.
Mr. Smith, did you not just concede to us that under your reading of this contract, or your belief under this contract, that if you go to arbitration and lose, that your client would be responsible for costs and fees to the opposing counsel?
Yes, Judge McMurdy, I believe that is the way the contract reads, that it says, if the arbitrator decides to award costs and make us pay costs, we will pay them. I believe that's what it says. One of the arguments that I'd like to take up is the question that you raised, Judge McMurdy, is about the procedural unconscionability issue, and do you have to explain? You have to take this case out of the context of a nursing home case, because you have to look at contracts as a whole. When you go and you get a cell phone at T-Mobile or Verizon, do you expect the clerk to explain to the consumer all of the provisions of the contract? Not just arbitration, but all of the provisions of the contract. The answer to that question is no. So when you get to the appellee's argument about they should have explained this U.S. Supreme Court in several decisions in several states as well have said the FAA and these contract neutral principles, they change the unconscionability defenses that can be raised. The Casaroto case that counsel cited, I believe that was the Montana case where the Montana legislature said arbitration has to be on the front page and in this size of font. That's procedural unconscionability provision. The Supreme Court said no, that is unenforceable. Provisions about whether you have to provide notice to somebody. Again, those kinds of provisions have been struck down by both the federal and the state courts. You don't have to read or explain these kinds of provisions to people any more than when you go to buy a car that the dealer has to explain to you what it might mean to say, if you don't pay for your car, we can get our attorney's fees. And that
Counsel,
raises another argument.
just because your time is running, I want to ask a standard of review question. In the relief that you're requesting and the positions that you advance, do we need to find that the trial court abused her discretion in reaching the factual conclusions that she reached, made the factual findings, or is this purely on the de novo side of this mixed question?
I believe it's on the de novo side. The application of the statute's issue of law. Interpretation of a contract is an issue of law for the court as a de novo review.
So you don't believe we need to disturb any of her factual findings in order to find in favor of your client?
No, what I believe the court did incorrectly was it reached improper conclusions from the factual record, and I'm unable to find it, but I can tell you it is in the Bremer case. If you look in the Bremer case, it cites, I think it's the Tovria Land and Cattle Company case, and it says when the facts are not in dispute, the appellate court is free to look at those findings or the facts on its own and to reach their own separate conclusions. So when you talk about, well, you didn't ask these questions, you didn't explain these things to her, the court can conclude as a matter of law
It
that
doesn't
you're not
matter.
required to do that.
Okay.
And the same thing with the costs. One other point is, I'll be very quick, Mr. Wright talked about the amount of money is reduced, and if we have to pay anything above a civil case, that's unfair. My time is up. Can I finish my thought?
You may finish your
All
thought
right.
in a sentence or two.
Yes. If you look at the Italian Colors case and then the Vamar Segueros case that they cited, which was a foreign bill of lading case, the Italian Colors course cited the Vamar case, and it said, in the Vamar case, they argued having to require people to arbitrate in foreign jurisdictions would reduce their overall cost. The Supreme Court said, we don't care. So the overall reduction in cost argument should be rejected. Thank you, Your Honor.
Thank you, counsel. We appreciate your argument today. We appreciate your briefs. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands in recess while we set up for the next case. Thank you.